we should do when a person would not meet the required level of understanding, and we think about what kinds of responses are possible in the criminal trial, maybe right now, or what we would like to see in the future. So we've talked a lot today about intention and intending the action. So what do you think the challenges of focusing more on intention in this broad sense that, as Bevin described to us earlier, what would be the challenges for that in the existing criminal law system, and what opportunities would a greater focus on intention bring us? Does anyone want to kick off the discussion? Difficult question. This way.
Okay, I'm out of my depth here, because as I was saying to Eilionóir over lunch, I'm a trained criminal lawyer, and we're not trained to think outside the box. In fact, we are rigidly constrained to operate and think within the box. I don't want to dodge the question. I'm not sure how to answer it. I think the starting point for me in this discussion is an observation that the object of the criminal justice system ought to be to divert as many people out of it as possible, rather than contain as many people within it as possible. Because we've been hearing about the consequences of convictions, consequences being inclusion, for example, on sex offender register, inability to find work, discrimination in housing, all the things that go along with having a criminal record. To revert to the question, insofar as I can start to touch on the discussion, not sufficient attention is given within the criminal justice system to the consequences of an action, as opposed to one's intent when one does something, and it's an ironic aside of the system that, in fact, many acts that are a great deal more heinous than others go unpunished because there are no consequences. So that, for example, if you drive a motor vehicle the wrong way down a motorway, as happens from time to time, including by some occasionally very drunk members of Parliament, and you don't have an accident, there are no consequences apart from possible detection and prosecution of the offender. If, on the other hand, in a drunken moment of lunacy, a youth punches a middle-aged man at the city centre in Dublin and knocks him to the ground, and the middle-aged man bangs his head off the ground and dies, then the youth is guilty of the offence of manslaughter. So if you think about those two angles for a moment, I don't think anybody in the room would say that the greater criminality must vest in the person who drives a motor vehicle the wrong way down the motorway at high speed, and yet they avoid any punishment because there are no consequences arising from their reckless, dangerous action, and both the youth, his family, and the family of the deceased person in the city centre incident were damaged forever. Starting point?
Yeah.
Okay, what I would say from the beginning is that this question about intention wouldn't be for sure answered today, and most probably we will having difficulties in answering this question in the future, but we need to start from somewhere. What would I pay attention is that when it comes to intention to commit a crime, what we do with the medicalization of the crime is basically that we put much more attention to people with disabilities than to other offenders. And we know much more details about them, we know much more details about their private lives, about their psychology, and then we think that their intention was different. It was somehow influenced by the illnesses they have and conditions they have, and that they intended to commit criminal offense because they were under influence of that, while we do not put the same question when it comes to other offenders. We do not put the same question when it comes to the offender who was not diagnosed, for example, with schizophrenia, and we have all the evidence that he or she intended to do the crime. in that context, it seems that we get information, more information from the defendant who is diagnosed with schizophrenia or with some kind of other medical disorder, and we think falsely that by knowing more and putting more stringent requirements to, let's say, sentencing, but conditionally, because it is not sentencing at the end, it is the forced treatment, we think that we may succeed somehow to prevent that person from re-offending again. And that might be completely false, because the forced treatment might not be always necessary, sufficient, might not be effective at all, and it might happen that person commits the crime even while being in the hospital. So the response to the committed crime might not be appropriate at all to the nature of the crime that was committed eventually. The other issue I would think about is also what do we want to achieve with the criminal justice system, and whether every time the punishment that we have now in the traditional systems is appropriate. And the example that Pierce showed us really shows that sometimes perhaps we can find alternatives to avoid severe punishment, to provide a support to person to not to re-offend, and not to claim that we need to punish the person for that committed. That guy from Australia wasn't punished for what he did. Intended, not intended, being influenced by the disease or not being influenced, that was not what was the matter. What was the important? What was the important was what kind of support he could get to avoid future offending. And if we look into that way in the future, perhaps we will be closer to the answer that you put today.
Florencia?
Thank you. Well, first of all, I'm not, I have to be clear that I'm not used to dealing with this, with the mens rea and the intention, because in the civil law system we have other kind of solution of this problem. So, but I think that we have to put, we have to pay attention in the consequence of every, the consequence of these names, of this label. Inimputability is in my country, insanity defense is in yours. But I think that we have to pay attention in the consequences of this, because sometimes there is a label, a fraud label, something because we have in our country that person are declared non-guilty by inimputability, but after that they receive a security measure which is longer than the punishment that they would have received if he were declared guilty. So we have to pay attention always in the consequence of the name is the same if insanity defense or inimputability is the same. So I think that we have to pay attention in this point, and also in the diagnosis, because the problem is that sometimes the psychiatrist and the psychologist also write a diagnose, and after this diagnose, the diagnose is associated with dangerousness, and so the judges build crime, diagnosis, dangerousness, confinement, and this is done. So I think that my experience as a defender is that we have to be careful with the diagnose and with the name of the problem, because sometimes it's only a cosmetic change, but the consequence is the same. It's the confinement for a long time without review, without guarantees, and I totally agree with you, Nick, about the support after or during the compliance of the in prison or outside the prison. No, when they receive something like libertad condicional.
Conditional release.
Yes. they need a lot of time persons with disability are denied of this possibility to receive conditional relief. But why? Because they don't have any support to continue with this possibility. And this is a typical this is discrimination when they are denied of this possibility that other persons have because they don't have support to obtain. Okay, this is.
Thank you. So I think maybe we could talk a bit more now about the practical exam. We'll take questions at the end of this session. We've time for questions, but I'll try to get through some of the discussion first, if that's okay. So we've heard a couple of examples today of what kinds of practical support would have helped people in the process, or what we could imagine in the future. So I might ask the practitioners, particularly on the panel, if they have any other examples to add to that of practical support that could be given, and with this support the person who might previously have been thought unable to participate in the trial might in fact, with support or reasonable accommodation or adjustment of the proceedings in some way, be able to participate in the process. Dara?
I'm not sure how this works in Ireland, because there's an interesting aspect of our law on fitness to be tried, which is, as a matter of general principle, if the person who's accused can't do, as a matter of intellect or intellectual function, I suppose, can't do a number of things to include instruct a legal representative, and that presumably means instruct a legal representative understanding what his instructions are, make a proper defence, understand the evidence, or in the case of trial by jury, challenge a juror to whom he or she might wish to object. If the accused person can't, by reason of intellectual disability for one reason or another, do one or all of those things, on a prima facie basis he is to be considered unfit to be tried, and so the trial doesn't take place. One thing that diverts slightly from that general principle is that if the case against the person is weak, it is possible for a trial to take place without their participation, although their lawyers may participate. So that if they are found, and here Davian's rigid or non-rigid separation of act from intention comes in. If they're found not to have done the act, then they're entitled to be acquitted, whether they understand what's gone on or whether they don't. So that's I suppose, one way that's built into the statutory mechanism of assisting and expanding slightly the idea of a trial taking place without the full participation of the person who's accused. On a slightly tangential issue, there is, in the case of rape trials, there is provision for a victim to have legal assistance. Now, victims don't normally have legal assistance in our trial process, but that again is a sense of thinking slightly outside the box in a special case. So we would need really, if we're going to enable and facilitate the participation of a person with disability in the course of a trial, we're really thinking about a redrafting and a restructuring of a whole class of persons. And firstly, I doubt very much it's going to happen at any point in the foreseeable future, since the criminal justice system tends to be the subject of cuts rather than expansions for economic reasons. Secondly, all of the professionals who are trained within the criminal justice system are trained to carry out, like I am, a fairly rigidly defined program. So lawyers would need to be retrained to participate in a new form of process in a new way. You would certainly need some social work assistance, and I can't think of a social worker in Ireland who might have the necessary skill set. Likewise, you need doctors specifically psychiatrists and possibly psychological specialists as well, possibly nursing assistants. So there's a whole plethora of things that need to be attended to guarantee the rights of people with disability in terms of full participation in the trial. I see none of it happening, and regrettably, and it is a matter of great regret, because while I think our criminal justice system is pretty good, especially by comparison with the criminal justice systems of many other countries, it has many imperfections as well, and we as a country, unfortunately, have not distinguished ourselves in rigorously enforcing particularly the rights of disadvantaged individuals, to which we are obliged by virtue of our participation in international covenants. Oddly enough, and if I may step completely off the platform for a moment, we buy in very much to the European Union impositions on us by way of expanding the criminal justice system as against persons who are suspected or accused of offences. But in terms of assisting the rights of people with disabilities, I think we're probably going backwards. Sorry.
No, that's okay. Do you want to give any examples of practical support that you've been able to provide or you've seen others provide?
Okay. Well, first, we in Argentina we don't have any experience in support, because this year is the first year that in the civil law the judges are thinking of support, because the civil code is very new and the system is very new for us. But first of all, I was thinking of these proposals, and the first I think is that we have to give training to lawyers and to judges and to police investigators in the CRPD principles, because in the criminal law the CRPD in my country is not known. So this is a really important thing to give training to the judicial operator. But after, if we are thinking of support, I think that we have to, the first question that I made was if the defendant is the person who has to appoint the support, not the system appoints the support for him, because the defendant is the person who knows who is the most accuracy or appropriate support to help him in this situation. Sometimes, for this reason, I think that sometimes or most of the time the best support is the family or the friend or every close friend, and not a doctor, and not a psychiatrist, and not a psychologist. I think that we are very new in this practice, and so we have the opportunity to introduce the best mechanism, and I think that the first question is, to me, is that the person is the defendant is who have to choose the accuracy support, and not the state, unless the judge, unless the prosecutor, because they have an interest, a special interest in the conflict. This is a point that I think, but you are a lot of more experience that we have, obviously, in this. I think so, I don't know.
Kristijan, do you want to make it?
Yeah, I would comment that although it may not be written in the law, and although that it might be that in some countries even CRPD is not ratified, all the people in the system have the possibility to provide support. They just don't know how to do it. Lawyers most often in criminal proceedings get cases, and I'm from Croatia. Croatia belongs to the countries of the continental law, so it is similar like to other countries of the similar legal systems. Lawyers get these cases upon the order of the court. Court says you must do work on this case because this person, accused person, perhaps he did a criminal act by being insane. So you must defend that person, and the lawyer doesn't get anything from that. It is a case that is just going on his or her caseload, and there is nothing for the lawyer what he should do or shouldn't do in that situation. There is no instruction. So this is the reason why I agree with the colleagues that education is very important. If the lawyer would know that supporting that person to stand a trial would bring a better success to get the case, that might bring a different outcome of the case. But the lawyers usually do not know that. Sometimes they have a lot of prejudices. Sometimes they agree even with the prosecution. They have the very passive role in the trial, and then person gets into psychiatric hospital because lawyers eventually, defense agreed with the prosecution that it should be like it is. These kinds of systematic problems will not be changed by the simple changes of the laws. We can do that, but if the people who are working in the system do not know that, nothing will practically change. Everyone has opportunity, I think, to provide support. What we must do from the academic point of view, from the points of the state, is to try to find the pathways, how to educate people and how to support them, the professionals, also to provide the specific kinds of support.
Dara, when you mentioned there the criteria that by which someone is deemed unfit to stand trial, it just struck me that the ability to challenge a juror that you might object to. I mean, this is something if strictly applied, I think many defendants would be found unfit to stand trial. So I wonder if we think what we're kind of describing today is how disproportionately people with disabilities might be found unfit to stand trial, and how that might have a very serious impact on them, especially if it leads to longer stays in hospital than they would have ever served in prison and so on, or indefinite detention or conditions in the community which are very, very restrictive on them.
Yes.
And they never have the opportunity to clear their name, for
Yes.
example, but which might arise if they proceeded to trial. So I wonder if we are imaginative about what's a realistic standard to expect of a defendant to stand trial, or should we just be applying this criteria to more people and a more fair application of the criteria? Because it seems to me that, well, not being able to tell the lawyer anything about what you want out of the trial or what your position is, I mean, if you can't do that, I'm not sure it would be fair to have a trial. But so yeah, trying to think about what would be fair criteria, I guess, which is one of the aims of what we're trying to do in this project, thinking more realistically. If anyone has any suggestions or comments on that.
We've had a couple of sessions this morning. I arrived late, so I missed the first session, but a couple of sessions where people talked about their own experiences within the system and were very ably assisted by advocates. Now, generally speaking, if I'm a solicitor taking instructions from a client, the last thing I want is a third person in the room who's telling me what they think is the best person for the patient. But in cases of disability, even relatively mild disability, it would be probably a good thing for a patient advocate to assist in articulating the needs of the client. The last thing I want to do, the people in the room should probably know that in fact the process of considering an accused person unfit to stand trial is a very rare process. In part because in many instances the consequences will be an indefinite commitment to custody, and that where you're talking about a relatively minor offence that isn't going to result, even in the worst case scenario, in a long period in prison, you're probably almost better off pleading guilty just to get rid of it. Okay, this is the tip of a social iceberg, basically, when these cases do tend to arise. And one of the things that has always troubled me is that the Director of Public Prosecutions, and that's the office of the DPP as opposed to the Director personally, the Director of Public Prosecutions will continue to proceed with relatively minor cases, even though they're causing grave difficulty for the system and for the accused and for the person who is the complainant in the case, in trying to reach a remedy through this very confined straitjacket of unfitness to stand trial process. John spoke very movingly earlier on about his issue in relation to, let's take the incident in the park. I can't think of any good reason why somebody should be prosecuted at all for being naked in a park and refusing to put the clothes on when they're told to do so by the park keeper, especially if there is some sort of underlying history of disability. I can't think of any good reason at all, and the Director of Public Prosecutions shouldn't sanction or permit prosecutions like that to continue. And I think that one of the bodies that would need to be involved in the greater holistic discussion about how to resolve questions of disability to the fairest possible advantage of the community as well as the accused, as well as the victim if there is a victim. It is the Director of Public Prosecutions who ought to take, in my opinion, a much more, I'm going to use the word aggressive, but it's clearly the wrong word, a forceful approach in simply not proceeding with cases where they're not justified, given the difficulties in resolving. Because you could be talking about, I've got I actually have the first unfitness to stand trial case I've ever had is ongoing at the moment. And it's going to take years to be resolved. And it's a dual unfairness on my client, who's an elderly person, and the complainant, who is a relative of my client, in relation to relatively minor sexual assaults on the complainant, getting on for 3 decades ago. The signs are that my client is descending into dementia. So he's never going to get better. He's not going to be committed to custody. And the fair thing for me, particularly bearing in mind the interests of the person who has accused him, would be for the case to be thrown out, to be withdrawn by the Director of Public Prosecutions. Because it's dragging on for years, going nowhere, and somebody needs to take a view about it. So I do think that the prosecution needs to be involved in the process. The process needs to become a much more holistic one than it is at the moment, which is absolutely hidebound by black letter law. Am I wrong?
No, you're fine.
Do you want to comment? Yes, only that I think that it's very very unfair to declare a person fit to plead and after send him or her to prison or to mental hospital for years. And the first thing, and I'm sure that the judge declare people unfit to plead because they have the confinement as a response. I'm sure if the day that the confinement disappear, they are not, and they are not continuous to, because the confinement is as a válvula, as a key to yes, to escape of this difficult situation. So they are very good when they declare unfitness to stand trial, but after the other phase of the judge appear when they send to confinement. But this is a paradox, because on giving, on protecting some right, they, in theory, in theory, they affected others, and in a very heavy way. And I think that when the elimination of the confinement, it will be the first key to obviously to reduce. And I think that our energy must be put, in my opinion, in thinking of a universal design of criminal process to everybody, and in the design of reasonable accommodation and in support, because the confinement is the key to the judges always.
I would just add a comment that when we mention supports, we need also to be very careful that supports may be influenced or manipulated,
Yes.
and that support must respond to the will and preferences of the defendant rather than his best interests paradigm. And in some cases, which may be very extreme, that person is not able to express nothing can be found, I think that in these cases we should draw the line and say, okay, we cannot continue with this kind of trial. Because continuing trial with not having the person present is a mistrial. It is something that is not fair. And even if we are not, in cases when we will not be able to provide the support, I think that legislators should have a protective mechanism to not continue the trial, because otherwise we could say, okay, we provide support, and support the person says us, okay, this guy couldn't tell me anything, but I conclude from his behavior that he did that or that.
So I think we're coming close to the time for questions, but I just want to ask one more thing. That came up, actually, Maria raised it earlier in her observations, that the last thing we want is more people in the prison population, and we're already concerned about the overrepresentation of people with a wide range of disabilities in the prison population, along with other marginalised groups, and the inability of the prison system to respond adequately to different needs that people might have. So in light of that, should we be thinking more about restorative justice or other measures that can be taken at an earlier point before things reach this level of the criminal trial? And do people have, there are of course limits to what restorative justice can be used for, and where the situations where we do need the formal justice system to recognise that a crime may have occurred. So I just want to get the panel members' views on the potential of restorative justice or its potential limits.
Well, I became interested in restorative justice on reading Australian studies going back for maybe 30 years. And I was quite impressed with the seriousness of the type of offences that could be dealt with under restorative justice programmes, including quite serious assaults between people who were sworn enemies in relatively small towns, and how they managed to be persuaded to resolve their differences by a skilled mediator. Restorative justice in Ireland is very much in its infancy. There's only one programme in the Dublin area, and it only takes, in the ordinary way, referrals from court and referrals from within its catchment. I think there's a second programme, experimental programme in County Tipperary, is that right? I'm a huge fan of restorative justice. I've got a couple of cases which have in fact been court referred at the present time, and it is unfortunate that it seems to be the position at the moment that you can only get to restorative justice by way of a reference from court, which I think is very unfortunate. It's a bit like the kind of school that I went to, which, as they say, was a special school where you had to be sent by a judge. It's not a particularly desirable thing that you should have to be in the criminal justice system before you can get access to restorative justice. In fact, I think it almost defeats the object. And furthermore, once you're in the criminal justice system, you then have to admit liability before you can get sent to the restorative justice program. So while it tends to be very successful in terms of outcome, getting in there is probably done all wrong. Again, there are resource issues, and most of the people who are involved in the restorative justice in the Dublin area are volunteers, and although they appear to be reasonably well trained volunteers. But what people tend to misunderstand is the expense of the criminal justice system, apart from the many millions of euro that are paid to defence lawyers in particular. The criminal justice system is extraordinarily expensive to run, with a huge prison population. Actually, it's a tiny prison population, both absolutely and in terms of the numbers of the population. But it's a much bigger prison population than we ought to have, with far too many people serving far too long sentences for far too little purpose, and having bleak futures when they get out at the end of the day. So I think anything that can be done to avoid people coming into the criminal justice system in the first place and fetching up in prison at the end is well worth spending money on. And every single study that's ever taken place shows that even at that, community-based sanctions are much better value, with at least as good, if not much better outcomes than sending people to prison. For me, the prison should be for predominantly hardline, violent, recidivist offenders or offenders of a particular type for whom confinement in the public interest and for public protection is really where we should be going. Most people who are in prison shouldn't be there at all. Restorative justice, I'm a massive fan. Very, very good success rate in terms of outcome, and highly desirable that public money should be spent on it.
I would add also that I'm also a fan of restorative justice, I have to admit that, and the criminal law itself is reserved only for very, very extreme cases. The situations when we put people in prisons must be hard. We cannot incarcerate somebody because of doing something which is not generally very harmful to the society. Or the same principle applies to placing people in psychiatric hospitals. What happens is that we get people declared being insane while doing the theft, and then being incarcerated in psychiatric hospitals for many years, much more years than for the more severe criminal offense where a person will be placed in the prison. Why this happens? Perhaps the answer is that there is a lack of earlier interventions when we recognize in the system that some people could be at more danger to get involved in the crime. Perhaps some of early interventions, but not done by the criminal justice system itself, more perhaps by the social workers and social support system, to prevent people to get into the crimes would be helpful. But we also need to be very careful with that, because we cannot assume that everybody who is having some kind of problems in their lives would commit criminal offenses, because we would put a lot of stigma to people. So everything should be done on a voluntary basis. I had a case when I was working in the Association for People with Psychosocial Disabilities, that one guy was accused for attempting to kill a child in the park. And that happened on the very same day after he first got into the hospital, and he said, "I'm feeling very bad, could you please admit me?" And then they told him, "But you did nothing wrong, and we cannot admit you in the hospital because you are just feeling bad today." And during the day he felt much more worse, and then he concluded, "I need to do something." He went to the park and he attempted to kill the child. What happened later in the system is that nobody recognized that the problem was in the medical staff that didn't want to provide him with support. They didn't got accused for attempted murder of the child. This guy did. I was the only one to bring a criminal complaint against the hospital, and I never got a reply from the prosecution. So nobody from the system is held responsible, although you could see at the earliest stages that something is getting wrong, but people are not getting support.
I think we're out of time, but if you want to say something very briefly before we take questions, because I want to make sure we get to the questions.
Only one thing, we have restorative justice, but it's really particular because the person doesn't need to admit liability. It's previous of the trial, so it's a good institution because there is an agreement between the defendant and the victim, and it's only to less severe cases.
Okay.
Yes, this is the only point. But if we are speaking about person with disability in prison, we have to remember the case X versus Argentina of the committee. I have because it's a photograph who was in the newspaper in my country. This is X, who was in this situation in trial, and he was in this situation in prison. And in this case, the committee said that, and I think that it's very important that we should remember that adopt appropriate measures and provide sufficient reasonable accommodation. The state have to adopt appropriate measures in order to ensure that persons with disability who have been deprived of their liberty can live independently and participate fully in all aspects of life in their place of detention. And this is very important if we are speaking about people with disability in prison. And if the lack The other point to me is that the lack of accessibility or reasonable accommodation would constitute cruel, inhuman, or degrading treatment, or that would undermine their physical and mental integrity. With this point, we obtain a lot of benefits, to people with disability, because our prisons are the el infierno, the hell. Yes. The hell, the hell. Ah, yes, that's the song. Yes, the hell. Yes.
Okay, on that cheerful note. John, I know that you had a question. So.
Yeah. Well,